The British East India Company was one of the most economically successful, if morally dubious, corporations in British history. Its lucrative business was to trade with countries in Asia, from India to Japan. Stock in the East India Company was therefore almost a certain path to wealth. A man named Richard Wright died in 1832, the owner of £2,000 of East India stock. This was a small fortune, and he left it to his great-nephew Daniel Vautier to be held in trust until he reached the age of 25 years. At the time of Wright's death, Vautier was still a minor. Now, it's important to understand the words carefully here. The will didn't say that Vautier should be given the stock if he reached 25 years. The will said that he should be given the stock, but that it should be held in trust until he reached the age of 25 years. So this was not a contingent gift where the gift would only happen if he reached age 25. This was an immediate gift of the shares, but they would be held in trust until he turned 25. When Vautier reached 21 years of age, he asked to dissolve the trust and to take absolute ownership of the shares immediately. The court found that because he was the only beneficiary of the trust, he was entitled to demand that the trust be dissolved and the trust property transferred to him absolutely. In Chancery, the Master of the Rolls said, where a legacy is directed to accumulate for a certain period, or where the payment is postponed, the legatee, if he has an absolute indefeasible interest in the legacy, is not bound to wait until the expiration of that period, but may require payment the moment he is competent to give a valid discharge. This decision was appealed by lawyers for the residuary beneficiaries who stood to gain the benefit of any gifts which failed under the will, for instance if Vautier died before taking his legacy. On appeal, however, the Lord Chancellor affirmed the decision of the Master of the Rolls, emphasising that the gift had been made, so was no longer available to those residuary beneficiaries. From this case, we get the rule in Saunders and Vautier that a sole beneficiary with legal capacity can demand that a trust be dissolved and the property given to them immediately.